Very good morning to all my dear students sitting here. I hope all of you are doing good. I'm also doing good. Thank you so much. I think I've told you this. Still no implementation. Okay. Anyways, your wish. So let's quickly recall what we have discussed in our previous session. As you know, we have discussed a few legal terms. You remember those legal terms? Misfeasance, breach of duty. That's it. Causing loss to others. And then and then Array, why do you go to overriding? Then you should say, sir, there is a possibility of injunction. है ना? Yes or no? What is injunction? Restraining order. That means you can stop that person who's doing that breach. ऐसा कुछ कर सकते ना? Connect करने की try करो. Try to connect it. Okay? So cause and effect, which we were saying, is shared between what? Misfeasance and disgorgement. So talk about disgorgement. So disgorgement means what? Effect. Okay, that just I explained. But what is it? Correct. So compensating for the loss which happened because of you, or maybe the profit which you have wrongfully earned, you have to refund it. That is disgorgement. Correct. Injunction is restraining order, stay order. Correct. Stopping someone from doing that thing which himself said he will not do. Okay. Overriding provision, which prevails over other provisions. Other provisions can be a few specific provisions or provisions of the chapter, of the act, or some specific acts, or all the acts as well. Isn't it? So, that is overriding provision, non-obstant clause. Okay, sir, we remember. Right. Then, if you remember, we have started with company law. We said first we will be taking up the basics and overview of the company law. So, Companies Act 2013 is the first law relating to companies? No, sir. There was Companies Act in 1850. Same way, 1866, 1882, 1913, and then, 1956 as well. Correct. Then, we have compared few things or few elements of 1956 and 2013. If you remember the preamble. So, preamble, objective in short. So, what is the preamble of Companies Act 1956? To consolidate and amend the law relating to companies and certain other associations. Whereas 2013, to consolidate and amend the law relating to companies. So that means other associations not covered. It is already covered. Good. Achha, now give me the preamble for 1913. Sir, you didn't discuss this. Still you can answer. Isn't it? Yes. What's your name? Oh, Sai Kumar. Yeah, tell me. Right. So he's saying to consolidate and amend the law relating to companies and other associations. You agree? Okay. So what makes you not agree, Miss Radhika? Huh? Very good. So here you will say consolidate and amend the law relating to companies. We are talking about 1913. Other associations was not there. That is why they had to write when they were writing the preamble for 1956. Consolidate and amend the law relating to companies and other associations. Yes or no, boss? If already 1913 covers, let us say certain other associations, is there any need for us to write again 19, what do you say, other associations? Come on, come on. No. Right. Then, coming to the scope of this act, 1956. Come on, answer. That yes, nay, answer. There were how many parts? 1 to 13. Comprising of how many sections? 1 to 658 plus schedules 1 to 15. However, when it comes to 2013 Act, there are chapters and few chapters have got parts as well, isn't it? How many sections are there? Section number 1 to 470 plus how many schedules? 1 to 7. Correct? Yes, sir. Then section number 1 of 1956 law. The Companies Act 1956 is the title. It applies to whole of India with suitable modifications for state of Nagaland. Correct? And then coming to commencement date, this such date as CG may notify in the official gazette. Now, if we talk about 2013, come on, the Companies Act 2013 is the title. Extends to whole of India. Extends to whole of India. Then further, it applies to not just companies which are incorporated under 2013 Act, that we know. So they are clarifying here that previous acts, if companies incorporate under previous acts, will this law apply? Yes, even to banking companies, electricity companies, insurance companies, or some other companies governed by special acts. Plus, they also said such other notified body corporates. Then coming to commencement date, such date as CG may notify in the official gazette. So that is also covered here. So 4 things are covered in section 1 of 2013 Act. What are those? Come on, title, extent, application and commencement date. Then 1 to 29 chapters. If you can recall those chapters, list. Come on, chapter 1, preliminary, right? Basic. 2, incorporation. No seeing the book, sir. No seeing the book, sir. I know you have written, but then you should not be looking into your book. Recall without seeing. Okay? Yeah, incorporation and matters incidental there too. 3, prospectus and allotment of securities. Without issuing prospectus, how will you issue the shares, debentures? Hai na? So I've given you the clue as well to remember. 4th one is share capital and debentures. 5th one, deposits. 6th one, charges. 7th one, management and administration including general meetings. I've told you again and again, general meetings, so that it gets registered, otherwise you'll forget. Board meetings is not covered here. Board meetings is covered in chapter 12. And what do you mean by charges? Security, I said. In short, you can remember it is nothing but security. Then chapter number 8, dividend. 9, accounts. 10, audit and auditors. Correct? 11, directors appointment qualification. 12 is also directors. 13 is also directors. 12 is about meetings, powers, restrictions. 13, remuneration, right? Appointment of managerial person. Next 14, III, inspection, inquiry, investigation. 15, compromise, arrangement, amalgamation, reconstruction. I've told you, in short, you say compromises. Next 16, prevention of oppression and mismanagement. 17, registered valuers, valuation, valuers. 18, defunct companies. 19, sick companies. 20, winding up. Defunct, sick, winding up. Close the company. Correct? 21, unregistered companies. 21A, producer companies. 22, companies incorporated outside India. 23, government companies. 24 I said, not 26. 26 is Nidhi companies. 24, 25 is relating to administration. So what is it? Registration office and not just fees. And then 25, company to furnish information or statistics. Then 27, NCLT, NCLAT. 28, special codes. 28, special codes. 29, miscellaneous. So if you are able to recall half of them also now, as of now, good enough. Slowly 2-3 times when we revise, you should be able to revise or you should be able to recall, all the 1 to 29 chapters, which you will be able to. Not that difficult, isn't it? If you straight away look into the book and then reply, do you think you will know how much you remember, how much you don't remember? No. And am I punishing you if you give the wrong answer or if you don't give the answer? Did I order any stick from Flipkart, Amazon? No. So don't worry. Okay, chalo. Now give me the list of schedules 1 to 7 that also we have discussed. Schedule number 1, table A to E, MOA. Table F to J, AOA. A for company limited by shares. B, company limited by guarantee without share capital. And then with share capital is next one, that is table C. Then table D, unlimited guaranteed company without share capital. And then with share capital is table E. Whereas when we talk about table F, which is for articles of association, for which company? Company limited by shares. And then table G, AOA again, but for company limited by guarantee with shares. First guarantee, no sir. With shares. Then without, and then unlimited guaranteed with shares, and then without. That's how table A to E, F to J dealing with MOA and AOA respective. Schedule number 2, depreciation, the rates of depreciation. Schedule number 3, financial statements. Schedule 4, independent directors. Schedule number 5 is managerial remuneration, which is of course not there for you. 6, infrastructure activities, and 7 is corporate social responsibility, CSR. This way we have got 1 to 7 schedules. Where? In company law. Did I frame them? No. The lawmakers only have framed the schedules, isn't it? And schedules will be in the beginning of the law or end of the law? End of the law. Correct? I told you this. Schedules are always at the end, giving details, forms, rates, like that, no? Formats. So out of these schedules 1 to 7, which are relevant for us at CA Inter for paper number 2, corporate and other laws? 1, 6 and 7. 2 and 3 maybe matters for the subject accounts. Then coming to chapters, which chapters are there for us in this 1 to 29? You remember, no, the gray shades are all applicable, I've told you. So 1 to 10, right? 1 to 10 plus 22, and then indirectly we know even miscellaneous matters, isn't it? Some sections from miscellaneous, not all sections, but some sections, a few section matters from miscellaneous chapter as well. Yes sir, absolutely. Now let's talk about what? Let's talk about the remaining basics of company law, as I've told you, isn't it? Yes ma'am. So this was the recap which we do on a daily basis. Now we'll continue with the further topics. Acha, someone ask you where is model articles? Someone ask you where is model articles? What will you reply? What did he say? Huh. Before that you were saying something. Huh. Very, very good. We'll say table F of schedule number 1. But sir, even G, H, I, J are articles, model articles only. I have told you which type of companies normally do we find? Company limited by shares. So unless the person specifies company limited by guarantee with share capital, without share capital, all that, you are going to say what? Table F, because we know normally that is the type of company. So people will not specify for that. People may specify for the remaining 4. Understand? People may specify for the remaining 4. Kindly understand. So it goes without saying, when someone is asking you where is model articles, what are we going to say? Table F of schedule number 1. Now tell me, where is model memorandum? Table A. Correct? Table A. Because again they are asking, if they are asking model MOA, that means they are asking for which company? Company limited by shares. It goes without saying. Okay, model, that means what? Pro forma, basically the general one, or a format, a pro forma, like that. So people use this term model as well. In your books also you will find. Okay sir. Now let's go ahead and discuss what? Doctrine. A few doctrines we will discuss, which you have read in your CA foundation. So before getting into those doctrines, please tell me, what do you mean by doctrine? What is the meaning of doctrine? Any idea? Doctrine, what do you mean by it? Don't say you have not read any doctrine in CA Foundation. These three are from CA Foundation only. And then doctrine of Cave Tempter and all you've read. So you have read some doctrines. I'm asking you meaning of doctrine. The word doctrine, what does it mean? Rules. That's doctrine. So my grandfather set some rules for our family. That is doctrine. Come on. So it's not that, would you say, simple, or you can say not, it's simple only, but then as an that only simply saying rules is doctrine. That's not right. So what is doctrine, my dear friends? Legal principle. What is a doctrine? Legal principle. Though which may not be a law, but has universal acceptability. Though it may not be a law, but still has got universal acceptability. That means people accept it. Though it may not be law, but still accept it. That's where it is doctrine. Are we not accepting the doctrines? Have you not read? If we didn't accept, or if we wouldn't have accepted, would you have read that? Do you think it would have been there in your books? No. Then? So what is doctrine? Tell me. Legal principle. आगे बोलना, रुक गए यहीं पे. Legal principles which may not be a law, but then still has universal acceptability. And what do you mean by universal acceptability? As I said, everyone follows it. Everyone has accepted it. That is the meaning of doctrine. Correct? Right, sir. So what is the source for doctrine? Kindly tell me. Right, madam? Put today's date, right? You've written the meaning of doctrine? What is the source for doctrine? Arey, abhi likhe apan, we have written already that it may not be a law. Now you're saying source for doctrine is law. What should I say? We'll say case laws, judgments given by the courts. That is the source for doctrine. Sir, if it is coming from law, then you may say. But then that should be your second answer, not the first one. The primary answer will be the court decisions, the case laws. That is the source for, come on, doctrine. People start using it because courts have said this. And they believe that it is not baseless, it is having some rational. Okay? Followed? Now we are talking about doctrine of constructive notice, doctrine of indoor management, doctrine of ultra vires. So first let's talk about doctrine of constructive notice. So put the heading, doctrine of constructive notice. We are in the context of company law, okay? We are discussing company law. So please understand, this answer also has to be in the context of company law now. Right? Doctrine of constructive notice. What does it say? If any outsider dealing with the company, if any outsider is dealing with the company, then he should read MOA and AOA. I hope you know MOA and AOA are public documents. Unlike partnership deed. Do you think partnership deed is public document? No. So if you go and want to associate with some partnership firm and ask for partnership deed, do you think they will give you? No. That's an internal document for the firm between the partners, deciding the relationship between the partners. However, when it comes to MOA and AOA, they are what? Public documents. So any outsider, any stranger who's dealing with the company can ask for what? MOA and AOA. And he has to read that. Only read? No, sir, understand as well. So read meaning it implies reading and understanding. And then do what? Verify whatever is written in that MOA and AOA has been complied with. Verify whatever is written in the MOA and AOA has been complied with. He has to verify. Who? That outsider, that stranger. He should not believe. He has to make sure that he verifies each and everything which is written in the MOA and AOA has been complied with or not. ऐसा घूर रहे क्यों रे भाई? Foundation you have read? No, I'm just revising. So that's doctrine of constructive notice, giving protection to whom? The company. And we understand from the doctrine that this is not possible, this is not easy. Outsider, do you think, stranger, do you think will be in a position to verify each and everything written in MOA and AOA? No, it's not possible, sir. It's not that easy, sir. Correct? So that's where which doctrine came? Doctrine of indoor management. So what happens in indoor management? The outsider, the stranger who's dealing with the company has to read MOA and AOA, no doubt about that, and then presume, assume whatever is written might have been followed. They might have followed this. He should not verify, isn't it? So, doctrine of indoor management is giving protection to whom? Outsider. And this makes more sense, isn't it? So, doctrine of constructive notice. What did I say? Any outsider dealing with the company, transacting with the company shall read MOA and AOA and ensure, verify that whatever has been written has been followed by the company. So thus we can say, as per this doctrine, who gets protection? Company. Who gets protection? Company. Whereas when I'm talking about doctrine of indoor management, as we said, we don't expect the outsider to ensure. So that's where they say the outsider who's transacting with the company shall read it, the MOA and AOA, and then presume whatever is written has been followed. So this doctrine gives protection to outsiders, unless obviously there are some exceptions to it. So if those exceptional cases or circumstances come, then that may not be the case. Okay. Right. So are we going to study this again in detail? Of course, yes. As I've told you, I'm just giving you overview now. So this was also because a part of your foundation, I thought I'll cover it. And when we go to the respective topic, we will again study this. Maybe the time which I will take there will be lesser because of the simple reason you already know that I just need to recall. So thereby my job will be easier as far as these doctrines are concerned. Okay, sir. Now let's talk about the next doctrine if you're done with this. Order or request? Those who said just a minute, so order or request? So request comes with the word please. Okay, no problem. So what's your name, ma'am? Madhvi. Right. What's your name, sir? Adam. Okay. See, it may take some time for me to get acquainted with your names and be familiar with you guys. So kindly don't mind if I utter wrong names just in case. Okay? Yeah, thank you. So let's go for the next one. What is the next one? Doctrine of ultra virus. Ultra virus. And what is the spelling of virus? VIRES, not US. Huh? It's VIRES. Okay, sir. So what is the meaning of the word ultra? Beyond. What is the meaning of the word ultra? Beyond. I didn't say ultra virus. Okay. What is the meaning of the word virus? Powers. Powers. Isn't it? So when I say ultra virus, what does it mean? Beyond the powers. Beyond the powers. So now question comes, sir, we are talking in the context of what? Company law. So ultra virus means beyond the powers of whom? company? Yes. If nothing is specified, ultra vires would mean what? Ultra vires the company. And where are the parts of the company written? MOA. MOA. So if nothing is specified, then it means ultra vires. Ultra vires means ultra vires the company. Ultra vires the MOA. In MOA, where are the powers of the company written? Where are the objects of the company written? Object clause. So that means if I say ultra vires, it also means ultra vires the company, ultra vires the MOA, ultra vires the object clause. It's all one and the same. Okay. What about ultra vires the AOA, the articles? So that you have to specify, sir. If you simply say ultra vires, we will not presume that to be ultra vires the articles. One has to specify ultra vires the articles. Understand? Same way, if I have to say ultra vires the directors, I have to specify that. People may not assume director can go beyond his powers, no, and act. Come on, a director who has been given some powers might go beyond his powers and act and do something and transact. So we have to specify ultra vires the directors. Then people will understand, okay, I'm talking about directors going beyond their powers. Same way, articles. But if I simply say ultra vires, then it is implied it is ultra vires the company, that means ultra vires the MOA, right? Memorandum. Ultra vires the object clause. Is it clear? Now tell me, ultra vires the company, can it be ratified? No. Sure? Very, very good. If it can be ratified, then there is no use of MOA or object clause. People will not believe, no? People will say they write something and they do something else only later on and get it ratified. Nonsense it will become. Just imagine. So, ultra vires the MOA cannot be ratified. Achha, by the way, what is the meaning of ratification? Ratification. Ratification. Approval. Act of confirming. Act of confirming or approving. Can I say is ratification? Yes, sir. When a person doesn't have the authority to do something, but still he does. Suppose a person doesn't have the authority to do something, but still that person does. And the person who has the authority says okay. So it means what? The act has been ratified. Like Madam Madhavi came now after we started the session. Came or not? Yes, sir. So did she take my permission? Did she take my permission? Come on. No. She has not taken my permission. She opened the door and just entered the class, sat. So do you think after I start the session, see, before I start the session, you don't take permission, enter, that's okay. But after I start the session, what is the etiquette? Yes, you should take the permission. Isn't it? She didn't take. She had come and sat. So she doesn't have the authority, but still she has done it. I have the authority. What did I say? Okay. So when did you say okay? Not by words, but by my action. Did I object? Did I say go out? Did I say why did you come? Did I say all that? No. So that implies what? I accepted. I said okay. Because already she is new to the class. So obviously she doesn't know about it. Isn't it? So I said okay, meaning by action. I didn't object. So that means I have confirmed her act. I have the authority and I have confirmed her act. So can I say now, I have ratified the act of Miss Madhavi? Come on guys, answer. Yes. So a person who doesn't have the authority still does. And the person who has the authority later on approves it. Confirms it. So that means it is ratification. Now, I'll change the scenario. Suppose she comes late after the session starts and she says, sir, may I come in? She says, may I come in? I say, okay, come. So now can I use the word ratification? No, this is not. So please understand, approval, but approval given later, that will be ratification. Act of confirming, okay, after the act has been done, that is ratification. Please understand the difference, isn't it? Suppose she comes late and she's asking permission, and I say, okay, I will say she has taken approval. That's it. She has taken my consent. But I'll not use the word ratification. When will I use the word ratification? When you have done the act without authority, and later on the person who has the authority is approving it. That is ratification. So, sir, who will have the authority? Depends. Depends on the context. I mean, in the context, we have to decide. In the circumstances, we have to decide. I cannot tell you who's having the authority. As far as this example of classroom is concerned, I have the authority. My class, I can decide. Correct or not? So, that, anyways, when we go into the transaction, we'll understand. So, now coming back to what we were discussing. We were talking about, can MOA, okay, anything done ultra vires the MOA be ratified? The answer is no. Because if they start doing that, then it will become funny. People will not believe your MOA, because they'll understand that you write something in MOA and do something else and later on get it ratified. Isn't it? You'll write, we'll do steel business and then do what? Cement business and get it ratified. Time pass hai ye to. Hai ke nahi? So, do you think people are going to believe you then? No. Good. What about ultra vires the AOA? Ultra vires the articles. Can it be ratified? It can be ratified. Okay. And who will ratify? Members. General meeting. Correct? Members in the general meeting. And how? By passing a special resolution. Very good. By passing a special resolution. Why? When ultra vires the MOA cannot be ratified, why is it that ultra vires the AOA can be ratified? So AOA is more focusing on rules, regulations, procedure. So procedure and all, we are okay with something going against it, and obviously if it is acceptable, then we'll ratify. We, in the sense, the members will ratify, but not in case of memorandum. Memorandum is what, and articles is how. So what, we are very serious. How? Okay, we are flexible. Okay, what can the company do? Object clause, that's what we stated, no? And how they can do it is written in articles of association. Clear? So now coming to ultra vires the directors. ऐसा fold your hands बोले तो क्या? Sincere बच्चे अपन लिखते भी रहना. Come on, you need to write as well, no? You have understood ultra vires the MOA cannot be ratified, right? Even whole body of shareholders cannot ratify it. Ultra vires the articles can be ratified by passing special resolution in general meeting. Sir, before that, we have also understood simply ultra vires means ultra vires the company, which is ultra vires the MOA, which is nothing but ultra vires the object clause. That also we have understood. So, as per your understanding, my dear students, please keep writing. Okay, don't wait for me to specify that. I have told you this earlier as well. Now, ultra vires the directors, can it be ratified? Ultra vires the directors, that means directors going beyond their powers, can it be ratified? Yes, sir, there are chances. And how can that be ratified? Who will ratify? Again, members in general meeting by passing galat, ordinary resolution. As far as articles is concerned, it is by passing special resolution. But when we are talking about ultra vires the directors, it can be ratified by passing a resolution, that means ordinary resolution. Simply I say resolution, it would mean ordinary. If it is special, we will specify it to be special. Please understand, guys. Okay. So ultra vires, beyond the powers is the meaning. Ultra vires the company, meaning ultra vires the MOA, ultra vires the object clause. And this cannot be ratified even by the whole body of shareholders. However, ultra vires the articles can be ratified by passing special resolution where? In general meeting. Ultra vires the directors, yes sir, can be ratified, but by passing resolution in the general meeting. Simply I say resolution. What did I say just now? That means what? Ordinary. I don't have to mention again and again ordinary. Okay. But special means I have to specify special resolution. I have to specify special resolution. Okay, can you pass the duster from there? Now, I said what? Can you pass duster from there? Now, who can pass? Tell me. Anyone, everyone, nahi. Anyone. But I say specifically, I want Karthik to pass that duster to me. So I have to specify, no, Karthik, please pass the duster to me. Why say I have to specify? If it is special resolution, I have to specify special resolution. Otherwise, resolution means what? Ordinary resolution. So I don't have to keep saying ordinary. Resolution, yeah, ordinary. But special, you have to specify special. How will people understand, my dear friends? Isn't it? Ultra vires. Simply we say ultra vires. What does it mean? Ultra vires the articles. Ultra vires the directors. No sir. Simply ultra vires when someone says, it means bolna, the company. Ultra vires the MOA. Ultra vires the object clause. If they want you to assume ultra vires the AOA, it's not possible. They have to specify that. Like I have told you for even this, tell me where is model articles? What will you say? Table F. No, I want for actually unlimited guaranteed company with share capital. Then you should specify, no boss, and then we will reply table I. You did not specify, how do you expect us to share this? Isn't it? So if they don't specify anything, that means we will presume they are asking for company limited by shares. Same way, model MOA. If they don't specify anything, company limited by shares. They are asking for company limited by shares is what we presume. Clear? So you should know when they are asking something and they don't specify properly. You should know what to assume and where they should specify. Correct? This is important. Why I am sharing this with you is when you write the examination, you will get some questions and their complete information may not be given. All the words may not be written and then you need to assume. So you should know what to assume. If you don't know what to assume, then how will you answer the question? And are you in 11th, 12th, 10th school where you can say question itself is wrong? So they will give the marks, they will award the marks. I need not worry. Is it going to happen here? No. Clear? Right, sir. Now suppose I say shares of the company. Let's say I say shares of the company are there with me. What will you assume? No, sir. First listen to me. That's where you are in a hurry always. थोड़ा सा रुकना पड़ता. क्या बोला मैं? I have some shares of a company. So I want to know which type of shares. So you assume equity shares. Sir, there are preference shares also. No. If those are preference, I will specify no preference. But if I am not saying anything and I say I hold some shares of a company, you will assume it to be what? Equity shares. This is what generally done. Clear? Now when I asked your name, what did you assume? I am asking your full name. No, first name. Why am I asking full name? Did I ask you full name? No. I said, come on, your name. She said Radhika. She said Madhavi. She said Shivani. There. He said Adam. Did they give full name? No. They assumed that I am asking what? First name. I am not asking full name because it's just to identify and address. So full name is not required unless we find 3 Radhikas are there. Then obviously full name is required because how will I know which Radhika is which one, right? So there it is required. Otherwise no. Okay, sir. So we understood assumptions are important. Right? Assumptions are important and we need to assume the right thing. Same way, one more example I'll take. Interest rate. Let us say interest rate is given. Take it 12%. 12% per annum. Now tell me, this interest rate you will presume it to be simple interest or compound interest? The answer is compound interest. क्या हूँ? मार्केट में जाओ, कोई सिंपल इंटरेस्ट लेता क्या? कंपाउंड इंटरेस्ट लेते. इंटरेस्ट पे भी इंटरेस्ट लगता. If you don't pay the interest for 1 month, Then second month you have to pay interest on principal as well as interest on interest of first month. They'll charge like that. So your assumption should not be simple interest. Your assumption should be compound, because this is what generally being done. Okay, तो समझ में आया? मुश्किल भी होगा, इतना easy भी नहीं है. तो धीरे धीरे you'll get used to it. You'll when you practice, this is the usefulness of practice. If you solve questions, if you practice, you will understand when information is missing, what are we supposed to assume and answer. Okay, Madhavi, you're able to follow? You've changed your name to Madhavi? Huh? Now, let's talk about other fundamentals. Let's talk about what? Other fundamentals. Acha, 1 minute, sorry, because you know it, I wanted to ask. See, something which is ultra vires the company, even whole body of shareholders cannot ratify. And 100% of members says okay, still not okay. Company law says not okay. No tick please. Huh? Thank you. So now question comes, sir, then if company cannot ratify it, what will happen to that contract? What will happen to the transaction? So who will be liable for it? Ultra vires the company हम बोल रहे हैं cannot be ratified by the company, and now you're saying company will be liable. Why will the company be liable, boss? Those persons who have entered into that contract or who have done that contract will be held personally liable. It's their fault, no? They have done something wrong. They've gone beyond the powers of the company. Company will not be liable. Who will be liable? That person who has done the contract. Maybe the director who has done that contract. He will be held personally liable. Haan, sir, risky, sir. That means if I am the director and I do something beyond the powers, then I am going to be personally liable. Yes. So that is where better you don't do. We want to discourage, no? So now will you get discouraged? Having known that if you do something ultra vires, you will be held personally liable. Will you be encouraged or discouraged? Discouraged. That's what we want. कुछ चीजें डिस्करेज करना बोल तो ऐसे ही रखना पड़ता ना बस. Don't go that side. Don't go that side. You will not understand. Now when we mention don't go that side, if you go, then this is the fine. Then probably you will stop yourself. Correct? That's human psychology. Chalo, great. Whereas in these two, ultra vires the articles, ultra vires the company can be made liable. Yes, sir. If it is ratified, then company is liable. If it is not ratified, then again company is not liable. Suppose SR was not possible to be passed. Right? OR was not passed. That means what? Ratification not done. Suppose I don't give permission. You come late. I say no, not allowed. Then what do? Go back home. Correct? Same way here, boss. If ultra vires the articles, ultra vires the directors, and it is not ratified, then what? Company liable? No. How can company be liable then? Then again those persons who have done that will be held personally liable. Understand? Try to know not just what is written there. Try to go beyond and try to know the application, implication. This is what is the implication of it. Isn't it? Chalo. So now let's discuss a few more things. Like what? Company form in a nutshell. Company form of business in a nutshell. In a summarized way. If someone asks you, what is company form of business? Sir, this we have read in 11th class itself, sir. So please answer. In a nutshell, I don't want detailed. Okay, I want in a very short way, okay, short version of what is company. What is company form of business? And when I say company, am I talking about any company or am I talking about joint stock company? Obviously joint stock company, right? The Companies Act is for what? Any type of company? No, joint stock company. Sometimes maybe certain other associations may come. Correct? Do you think you are giving me company, I am giving you company? We are a company? Yes, sir. But is it the same company under Companies Act? No. Correct or not? Even partnership is what? Company. But then is that company, partnership company, is it that company which is covered here? No, sir. That is why I go back to the definition of company. What is written there? Company means company registered under this act or previous acts, previous Companies Act. Then only it is called as a company under Companies Act. So you might be using the term company generally. Who knows? Right? Now, opposite side you may find a shop where the name written is what? Let us say Rinku and Company. So that does this mean that that particular shop is carrying out business in company form under Companies Act? No. Are you getting my point? It can be company under company law only when it is registered under company law, whichever company law, but has to be registered under company law. Right? So that is all assumption. So when I'm asking company form of business in a nutshell, you tell me, that means obviously I'm talking about company under company law. Come and tell me fast. Sir, there will be shareholders who will put in money. There will be board of directors who will be managing it. And there comes auditor who will come and verify whether everything done is right or not. That's what is company form in a nutshell. There are shareholders, no, who are going to put money. And how many of them are there? So any number can be there, because if we talk about public limited company, you know, is there any restriction on maximum number of members? No, sir. So that's where what can happen? Unlimited number can be there. Sir, if it is private company, then of course unlimited cannot be there. You know how many members are there in private company? Maximum 200. So we have that idea. Correct. So shareholders puts in money. Board of directors manages what? The operations, the affairs of the company. And then auditor comes in, verify whether they have managed it well or not. They have managed as they promised. They have managed it as per the laws, relevant laws. He's going to come and check, no? What's the job of the auditor? What do you mean by audit? Check, verify. Correct? Sir, okay, we understood these three. Right hand side you have kept some picture with three persons showing some mask, something like that. What is it? No, not that now. But I just want to make you understand that there is a possibility of playing a dual role. Meaning, one who's a shareholder can also be a director. There's a possibility. So it's not necessary that the shareholder cannot be a director. No, that's not the case. Otherwise, how will Mr. Ratan Tata become a director in Tata Group of Companies? How will Mr. Ambani become a director in Reliance Group of Companies? Isn't it? They're shareholder as well as directors there, no? Come on, guys, answer. Hai na? So we understand. So there is a possibility a person might be a shareholder plus a director as well. But can that go with even auditor? He's a shareholder as well as auditor. He's a director and he's also an auditor. No, not at all. Boss, we want independent auditors. Suppose the shareholder of the company himself becomes the auditor of the company, and the board is trying to cover the wrong deeds of the company. This auditor will also support him then, because he knows if he expose them, then the share price will fall and his personal wealth also will come down. So do you think he will expose the company? No, he will expose those wrongdoings? No. So if you want to appoint some auditor, he should be an independent person. He himself is a shareholder in that company. He himself is a director in that company. Then there is fun of audit, you can say. It's not going to achieve its objective. We want independent audit always. So it is not written no independent auditor. It is implied, it is assumed. When we say this, obviously auditor has to be independent. Now your parents, suppose your parents only correct the test papers. Okay, examination papers which you write, let's say CA Inter examination papers, and ICI says your parents only will correct and give marks. What will they do? 90 plus. Because that is not independent checking. Am I right or wrong? और वही बाहर वाला करेगा तो independent checking possible hai, and what you deserve is what you will get then. At least chances are there or not? Yes, sir. You go and ask your mom today, how do I look? What will mom say? Beta, you're the handsome or the most handsome boy in this world. Yes or no? You go and ask your mom, or you also say no, mom, you're looking the most beautiful lady in this world. Because you are her son or daughter, that's why you're saying this. Correct? That will be there. You cannot be giving an independent judgment there. Isn't it? Chalo. Let's go for the next one. What is the next one? Two-tier management structure. Two-tier management structure. In a nutshell over, it was nutshell. So nutshell I've shared. Two-tier management structure. I'm waiting for your answer. Two-tier management structure. What do you mean by it? Wait. Yes, Balaswamy. Okay. And don't always sit and answer. Okay. When specifically I'm asking you, Bala, that means you should always get up and answer. Unless I say, sit. Now also not standing. अरे आराम से पीछे दीवार पे रिलैक्स कर रहा बच्चा हमारा, अभी सो जाता थोड़ी देर में. हाँ. Okay, yeah. Proceed further. That's it. Okay, good. Sit. You were saying something, Mehul? Okay, no, not that way. Anyways, good. At least you think. I appreciate that. But let me give you the right answer. See, when we say two-tier management structure, what we mean is sometimes the decisions are taken by even shareholders, members. Normally, generally, who will take the decisions for the company? The board of directors. But then there is a possibility of even members getting involved in the decision making. Understood? Come on. So that's why two-tier, no? Generally we know board, but exceptionally we know even who can come? Members, shareholders. So that way there are what? Come on, there are what? Two layers, right? Two-tier. Sir, now we want to understand when will the board decide, when will the members come in? Obviously, routine matters are there, then it is the board which will take the decisions. Non-routine matters, they will involve even shareholders, that is the members. Suppose now company wants to go for merger acquisition. Do you think that they will involve members in this? Yes, sir, of course. Of course. Correct or not? A company wants to go for merger acquisition. Board of directors themselves will decide that. We'll go for merger. Why should we ask shareholder? Shareholder has put in money. So is it not your duty to ask the shareholder, are you okay if we go and merge this company with another company? Don't you think we should be asking them? So that's where what members also will come in. Followed, non-routine matters I'm talking about. Suppose they want to decide on the discount policy. Who will decide? Board will decide or board with members will decide? Board. Why will you involve members there? Isn't it? Suppose the company wants to appoint an auditor. ये रूटीन है क्या? रोज वही काम करते क्या अपन? No, it's members who will appoint auditor. For your information, it is board who will suggest the name, but it is members who will appoint the auditor. Whose money it is, boss, in the company? Shareholders, members. Start using the word members than shareholders, because you know there can be companies without share capital also. So there will be members. Members are everywhere. Shareholders are not everywhere. One of the ways of becoming member in a company is shareholding, but it's not the only way. Okay, because without share capital there is no shares. There are no shares. Still there are members. So there is another route, no? Aisa. So kindly understand that auditor will be appointed by whom? Members. Because ultimately, who is the owner? Who has put in money in the company? Members. So they will decide. Board is working. Now you give the right to the board only that you only appoint the auditor. So they will appoint that person who will favor them, no? Don't see, we are the board of directors. Let's assume we five of us, okay, are the board of directors. And appoint Mehul as the auditor. And tell Mehul, Dekh, whatever we do, you should say it is right. Then only we'll appoint you and give you this fees. Will he not listen to us then? Because he knows he goes against us, we'll throw him out. Will it be right? No. That's why we don't have the right. If we are board of directors, we don't have the right. Who has the right to appoint auditor? Members. Isn't it? We'll go and verify, we'll check, the auditor will check. Everything is done as per law. Everything is done as per those documents. Agreements are all properly framed, followed. So like that, auditor is going to give his report then after checking. Correct? So it's members who will appoint, not the board of directors. So that means we understand, boss, it's not board every time who's taking the decision. Generally board, no doubt about that. That means routine. But exceptional matters, non-routine matters, board with members or only members. Like appointment of auditor, only members will decide. They'll not say first you pass a resolution, then we'll pass. No. Board will just suggest the name and it is the members who will, come on guys, answer, who will appoint. Okay sir, followed. Two-tier management structure, I have written in bracket in the heading. If you see something, you might have used this word even in your 11th class, isn't it? How do you pronounce it? Oligarchic. Okay. So oligarchic management, when someone says, meaning two tiers of management, two layers of management, two types of management, directly board, indirectly even members. Obviously. Now you should be asking one question to me. Sir, which are those matters where members will interfere in the decision making? Can you give us the list? And I will say, see, it's not me or you who will decide that. It's the law, company law decides. Like we said just now, we said, ultra vires the articles can be ratified by passing special resolution. So members are deciding on that. So law has specified this, that if anything is done beyond the articles, then members can ratify by passing special resolution. Who said this? Not me, the company law. Same way company law also said, ultra vires the directors, who will ratify? Members by passing ordinary resolution. So they will let us know where will members come, and they will only let us know, the law only will let us know how will that be done. How will they take the decisions? Obviously by passing resolutions. But which resolution? Who is going to specify this? Come on, answer. Law, the Companies Act. Clear? Chaliye. So two-tier management structure you have understood. Now let's go for appellate structure under company law. Appellate structure. What is this appellate structure, sir? What is this appellate structure? Where can we appeal? Appellate comes from which word? Appeal. So if you have any grievances, where do you go and appeal under company law? You may have some grievances, no? You are a member of the company, you may have some grievances. You are a member of the board, that means a director, then you may have some grievances. Correct? Like that, people might have grievances or not. You understand the meaning of the word grievances? What is grievances? You have some problem, you have some issue, you have some concern. You want to make some complaint. Where do you go and do that? So that way we are talking about. Correct? ROC did something wrong. You want to file a case against ROC's action. Where do you go and do that? Okay. So answer is what? NCLT. Let's say you file a complaint, you file a petition with NCLT, and NCLT gives the order after all that process of hearing out, contention, intention, evidence, witness. NCLT gives the order, but you are not happy with the order. Then what can you do? Appeal further. NCLAT is also there, no sir? Chapter number 27, if you remember, NCLT and NCLAT, National Company Law Appellate Tribunal. National Company Law Tribunal, NCLT. Appellate Tribunal, NCLAT. So you'll go to NCLAT and appeal further. Suppose NCLAT also passes order and you are not happy, then Supreme Court. So like that, there is some hierarchy. Okay, there is some hierarchy. Go to NCLT first if you want to file an appeal, and then NCLAT, then the highest one is Supreme Court. Sir, but sometimes even special courts can come, no sir? Yes, that's where I've written plus special courts as well. Is special court a judicial body or quasi-judicial body? Very good, quasi-judicial body. Just because the word court is there, I've told you, doesn't mean it is always judicial body. Acha, what about NCLT and NCLAT? Quasi-judicial bodies. Supreme Court, judicial body. Acha, who gives the power to the government to establish judicial body? Constitution. What about quasi-judicial bodies? Thank God you remember. Good. That way if you keep revising, no, it will get registered. Right sir, we understood. Special courts may come in some cases. Which cases? Law will specify. You have chapter number 28 dedicated for special courts in company law. So when they establish, will they not help us understand when can we go to special courts? They'll just establish and leave it. No. Special courts should know which case we can take, which we cannot take. Same way we should know when can we go to special courts. So do you think all that is defined well or not? It is. See, the beauty of company law, as I was mentioning yesterday as well, is that whatever you can think of is there in company law. Isn't it? There are so many things which one can think of in company form of business for which already law is there. Unlike partnership, there are so many things which are missing in partnership form of business. But company law is not like that. It's a professional form of business. See, before you do something, before something happens, if you already have rules, regulations, is it professional or unprofessional? Professional. Correct? So company law, company form of business is considered to be the most professional form of business. Understand? Right, sir. Now let's discuss appellate structure generally, because now we discuss under company law. So a question might come, or maybe you may have some doubt. Generally, what is the appellate structure generally? Not relating to company law, generally. Know it? No. Okay. So what do we have? Court of Judicial Magistrate of First Class. क्या रहता? Court of Judicial Magistrate of First Class. Court of JMFC, we call it. Or MMFC, Metropolitan Magistrate of First Class. Or PMFC, Presidency Magistrate of First Class. Understand? Sir, but if we are not happy with this, with their decision, then we can move on to District Court, Session Court, City Courts. Still not happy, then sir, High Court. Still not happy, then sir, Supreme Court. Generally. Yeah, obviously we have to talk like that only. Whenever we talk about appellate structure, we start with bottom. Here also we did that only. NCLT, then I said NCLT, then I said Supreme Court. I didn't start with Supreme Court. I didn't start with apex authority. I started with lowest authority. Sir, below this also is something there. Yes, it is there, but I will not get into it now. Not required also for us as such. So if you are interested to know, we can discuss, but that we'll discuss later. ग्राम पंचायत are there, खाप्स are there, मुंसिफ्स are there. वो बाद में बात करेंगे. अभी too much हो जाएगा मैं बोलूंगा तो. ठीक है ना? वो जरूरत भी नहीं है. Actually जरूरत है तो बताता भी था. जरूरत ही नहीं. But still, if you are curious, you have that anxiety, or maybe you can say inquisitiveness to know, we can discuss later. Okay? Not now. Right, sir. So right now we'll discuss just 4 layers in this general one. So first one is what here? JMFC. है ना? No. Court of JMFC. Say what? Because see, JMFC is what? Judicial Magistrate of First Class. So you have to go to his court, no? And file the petition. Like High Court. High तो आप तो ये नहीं बोल रहे ना, Judge of High Court. आप क्या बोल रहे? High Court. Are you getting it? You have to use the word court here also. Court of JMFC, PMFC, MMFC. Not happy, go to district court, session courts, or city courts. Still not happy, then High Court. Still not happy, then Supreme. Sir, as a chartered accountant, I should know this, what do you say, legal structure, laws and all. Yes, you will be coming across this when you talk about Income Tax, Companies Act, GST Act. All these are what? Laws only. So we will be dealing with laws. Obviously, we should know. We are not going to become lawyers. We are not aiming to become lawyers, isn't it? But then we will be dealing with laws. You also have the right to appear for your client in this tribunals, Income Tax Appellate Tribunal and all. So you should know the legal system, legal structure, no? Then only you can represent your client in Income Tax Appellate Tribunal, etc. Samjha? Come on, guys. So we don't aim to specialize, but at least fair knowledge is required, because in practice you might be getting some work relating to it. Clear? Right, sir. So next one, sir. Appellate over. So now let's discuss administrative structure of company law. Okay, under company law, administrative structure. Right, administrative structure. What do you mean by administrative structure? Sir, in the academy also we have some administration team who administer things. Yes or no? Same way, when it comes to company law, to manage that company law, we need some team, administration team. Yes or no? Yes, that's what. So one person already you are familiar with in this administration team. Company law, administration team, one person is already familiar. Under company law, we are talking about company laws administration, Companies Act administration. You are familiar with one of the team members of that administration team. ROC, Registrar of Companies. Are you not familiar with him? Yes, sir. We have come across ROC. Right. So topmost is MCA, Ministry of Corporate Affairs, which will be assisted by a secretary. Okay, Ministry of Corporate Affairs, in short called as what? MCA. This is for the whole of the country, obviously. This is for the whole of the country. And who's that Minister of Corporate Affairs? Minister of Corporate Affairs. Who's the minister currently? Nirmala Sitharaman Madam. Arey sir, she is Finance Minister. We also know, boss. Can't a person hold two ministries, dual ministries? Yes, she is holding. So she is not just the Minister of Finance, but also Minister of Corporate Affairs. In this Modi government, always they made sure that whoever is handling Finance Ministry will handle Ministry of Corporate Affairs. Arun Jaitley sahab was there. He was also the same, Finance plus. Same way Nirmala Sitharaman Madam also is, handling both the ministries. Okay. See, can't I teach two subjects? I can. No? I'm teaching this subject. Let's say I'm teaching auditing as well. I'm teaching financial management as well. I can teach. Same way, I'm a minister handling this ministry plus another ministry. Now KCR has decided he will fight contest elections from two places. Gajwal, Kamareddy. Has decided no. So can he contest elections from two places? Yes. Understood. Capable was, person is capable. The ministries are linked. the work can move on smoothly. There are various reasons like this, because of which you may find one single person for two ministries. Three also is possible, for your information. No, no, not last. I'm just telling you three, four, five. It depends. So there's no rule, thumb rule that one ministry, one minister, one person only. Nothing like that. Okay? Right, sir. Sir, this ministry of corporate affairs is for the whole of the country. Correct? And if they have to administer well, then they have to divide this country into regions. Then we can administer well, no? See, whole of India, central government is there. Then we have what? State governments also, no? That means we have divided the whole of the country into what? States. And we said, let us have a state government as well, because managing the whole of the country will be difficult. Just imagine there are no state governments, there is only central government managing it. Is that easy? No. Same thing here. Again, state wise, if you go, then district wise will come. Administration is there district wise or not? Same way here, if you see, region wise and then state wise. Whole of the country, MCA. Region wise, regional directors. In short, we call them as RD. What? RD, regional director. State wise, generally, state wise. Come on, ROC. देख रहे भी, बोला भी, फिर भी नहीं बोल रहे. Waiting for me only to say this, huh? Come on. ROC, Registrar of Companies. See, if you speak no, the effect will be different. If I speak, you listen, that's good. But you also need to utter, you also need to speak out. That is the effective way of learning. Okay? Followed? Yes, sir. Sir, how many regional directors are there, sir? How many regions are there, sir? Like your ICI also has divided into regions. No, you belong to southern region. Correct or not? ऐसा थोड़ी बोल रहे country level पूरा एक ही साथ administer करेंगे. They also have taken care that let's make it. How many regions they made it? 5. Northern, Eastern, West, Southern, Central. So 5, because they thought 5 is enough, or they thought 5 is required. So 5. Now same question comes here. This MCA, which has divided the country into regions. How many regions? So answer is here for you. How many? 7. Which are those 7? North anyways there, west, south, east. 4 to hai. These 4 are there. Plus 3 more are there. Which are those 3 more? Northeast, northwest, southeast. And if you want to know where are the offices of those regional directors, I have written it for you, the city names, if you could see. Where will you find the regional director of northern region? Noida. Southern, Chennai. West, Mumbai. South, Chennai. Correct? South, Chennai. East, Kolkata. Come on, northwest, Ahmedabad. Northeast, Shillong. Southeast, Mana Hyderabad. So like that we have got what? 7 regional directors. Northern, Southern, Eastern, Western. Or you can simply say North, East, West, South. Plus Northeast, Northwest, Southeast. No Southwest, Southeast. Southwest, Southeast बोलेंगे तो फिर South का जरूरत क्या है? ठीक है? Right, sir. Then coming to ROCs, the general rule is one state, one ROC. But there are exceptional cases where one state but 2 ROCs are there. And do you know them? Which states it is like that? Tamil Nadu and Maharashtra. Tamil Nadu is one state, but there are 2 ROCs. ROC Chennai, ROC Coimbatore. Same way, Maharashtra. ROC Mumbai, ROC Pune. There are 2. One state but 2 ROCs. Sir, why like this? More number of companies, obviously. More work. So, one person cannot handle. That's why they appointed 2. Clear? Hmm. Then there is another type of exception. Two states or more than two states, but still one ROC. Like seven sister states in the east. कौन से seven sister states in the east? Mizoram, Assam, Manipur, Meghalaya, all that. Seven sister states. One ROC only. Why like this? Lesser number of companies, lesser work. So why to have one ROC for one state? Not required. Is it clear? So this type of exceptions are there. Generally, if someone asks, you will say one state, one ROC. So then you have written one more thing there, CRC, Centralized Registrar of Companies. Recently, this was done. Centralized Registrar of Companies for few matters. Like you want to reserve the name of a company, you go to CRC. You go to CRC. Like that, there are some specific functions. We'll discuss that later. Okay, so there is someone called as CRC as well. So that's also like an exception, because generally one state, one ROC, but CRC, as the name suggests, for the whole of the country, only one. What is the full form? Centralized Registrar of Companies. Correct. So now, did you follow administrative structure? Administrative structure under which law? Company law. So like that, every law will have some administrative structure. Obviously. Every law will have some appellate structure. Obviously. Let's go for the next one. Okay, you can have a look at this chart if you want to. Right? This picture might help you. Left hand side is what? Regional. Yes or no? Left hand side, regional directors. Northern, see, northeast. पढ़ो ना भाई, दिख रहा ना सब? Okay, and then right hand side, ROCs. Now let's talk about the next one. And what is the next one? Adjudication. Heard of this term, adjudication? Come on, you're on the right track. You're on the right track, Karthik. Please answer. Come on, Karthik, stand up. Without slippers also you can stand up. No problem. Judgment. Okay. He's saying adjudication. I said no. Adjudication. So somewhere judging is the word. So judgment. Correct? No? He has picked it right. That's how you pick it. So, do you think this adjudication is a process or is just one task? It's a process. It involves. What do you mean by process? Where series of steps or series of activities are involved. Not just one activity, one task, but series of steps, activities, tasks are involved. That is where it is called as process. Correct? So adjudication is a process. Where what do you do? Sir, we file a complaint. Then what do they do? Then what do you do? Trial will be there, hearing will be there, right? Something there, no? Or directly you file the complaint, they'll give judgment. Based on your complaint, judgment. Is it like that? No. There will be trial, there will be proceedings, and then finally the judgment will come. Correct or not? So see, upon a complaint received, what do they do? Hold an inquiry. Hold an inquiry. There will be trial, there will be some proceedings, isn't it? And then finally what will happen? The order will be passed. Declaring the person guilty, imposing penalty or not imposing penalty. Correct? So kindly understand, adjudication is not just one activity or task. It's a process. It's a process. So once the adjudicating authority receives a complaint, he'll not simply pass the order. There will be trial, there will be inquiry. And then when that is completed, you will see that an order is passed. That order might be to impose penalty, not to impose penalty, might be to declare some person guilty, that accused guilty or not guilty. Then you might ask me this question, sir, who can be the adjudicating authority? Is it only judicial bodies? No. So that's where I've written it. It's not just judicial bodies, but even quasi-judicial bodies, or even even central government or some authority appointed officers. So CG may appoint some officer, SEBI might appoint some officer. So like that, those officers might be adjudicating authority. Clear? Judicial, quasi-judicial, or even CG or authority appointed officers. Right. Okay, sir. So that picture is connecting something there? Do you think is so that means what here? Two parties and the adjudicating authority. That's how it happens. Next heading you put factors considered before imposing penalty, because we talked about penalty now, order to impose penalty, not to impose penalty, obviously. Now what are the factors which are considered before imposing penalty? This is over, no? Or you're still writing? Right. So when we said the adjudicating authority will pass an order, and that order may be to impose penalty if the person is found to be guilty, but if the person is found to be innocent, then no penalty. So now the next topic which you're writing is factors to be considered before imposing penalty. What are the factors they think of? What are the things which they consider before imposing penalty? Intention of the person, intention, intentionally he has done, unintentionally he has done. Suppose the person who is guilty is has unintentionally done it, penalty might be lesser. Whereas intentionally he has done, penalty might be more. First time he has done that offense, seventh time he is doing that offense, where will the penalty be more? Seventh time. Obviously he is repeating that offense again and again. So the authorities will be harsh here, isn't it? The authorities will be harsh. So one has to understand that like that there are certain factors which the adjudicating authority has to consider before imposing penalty. So I have listed a few here. Just have a look at it. Nature of default. What type of default has been done? Whether it has caused injury to someone? No, it has not caused injury. If it has caused injury, then which type of injury matters or not? Many a times on the road also, when something probably irritates you and you start shouting, let's say you are on the road driving, some person takes some cut, something like that, drives rashly, and then you start abusing him, you start fighting with him, then what does he reply? Nothing happened, no? Kuch hua to nahi na, kyun chilla rahe? That means he's trying to tell you that no injury happened. No, then am I a defaulter or am I at fault? No, but actually he's at fault. Rash driving is just because it did not hit someone, just because no injury no one was injured, does it mean he's right? Come on guys, answer. No. So that's where you need to understand here that nature of default matters. If you have done default, then whether it has caused injury to someone, not caused injury, what type of default have you done? Correct? Next. Second, what did I write? Repetition, like we said, first time, seventh time. Next, size of company, because we are talking about company law. That's where I've written that size of company. Bigger the size of the company, bigger will be the impact. So if bigger is the impact, penalty will be more. Lesser is the impact, penalty will be lesser. So that's, they'll consider this also. Next, nature of business. Nature of business, manufacturing concern, trading concern, again which sector, all that they'll see. Because with this also they'll know the impact. impact of that offense which has been committed. Next, injury to public interest. Whether this thing has injured the public interest, it has affected the public at large. Yes, that means penalty will be more. Sir, but what is public interest, sir? Okay, we'll explain. I'll explain, don't worry. Next, intention. Then, etc. Meaning, the list is not exhaustive. Inclusive. Correct? The list is not exhaustive, it is inclusive. There can be more factors. I just listed out a few. Correct or not? Now let's come to, sir, what do you mean by public interest? What do you mean by public? People. Do you think only for this I am saying let's discuss? If it would have been that simple, public means people. Okay. So she's saying members of the company are public. She got inspired from this particular picture, I guess. See there, first one, shareholders, public. Correct, no? Okay. So members of the company is public. Come on, I'm waiting for others to respond. Okay, other companies also is public. Okay. Who else? Array, examples, you give me specific answers like how she gave. Right? She said members, shareholders, and then you said other companies. Like that, you give me specific ones, boss. Customers, suppliers, financial creditors, institutions. Come on, yes or no? So we cannot stop at simply shareholders. Shareholders is public. तो बाकी के क्या है फिर? वो ऐसा हो गया, आपका पैसा पैसा, हमारा पैसा पानी. Your money money, our money water. So we need to understand when we say public, it should cover more or less all the sections of public. That means not just shareholders, not just directors, not just auditor, not just employees, not just customers, suppliers, institutions, other companies, competitors, government, research agencies, all are what? Public. So now you have to answer, what do you mean by injury to public interest? When will we say that public interest is injured? Is it that everyone whom we just referred, just now we referred, everyone should get injured? Then we will say it is injury to public interest. Anyone. Suppose I say only creditors of this company got injured, that is not injury to public interest. No sir, those creditors are 1,000 in number, still it is not injury to public interest. Suppose you say, sir, all the members of this company, and that 2 lakhs are there, sir. Now, 2 lakh members are there in this company, they got affected. Still, I will not say injury to public interest. Please understand, all the sections or at least few sections, more number of sections should get affected. Then we'll say public interest got affected or got injured. See, suppose 2 students out of this 50, 52, I don't know, right? 2 students got affected. 2 students are not able to follow. Will I say students getting affected? Come on, guys. No. But if I find 20 students are not able to follow or got injured, then I will say students' interest is getting affected. Sample size you just consider or not, boss? So, injury to public interest, one has to understand all the sections. All the sections meaning, sir, shareholders, directors, employees, customers, vendors, suppliers, financial institutions, government, competitors, like all getting affected to some or the other extent. See, everyone will not get impacted or injured to same extent. Different. Level might be different, but should be affected. Then we say injury to public interest. If not all, yeah, few of them. few of them. Then we say injury to public interest. Clear? Clear? What is the next one which I'm taking? Penalty. I want to discuss something here in penalty. Okay. First one, types of penalty. Monetary, non-monetary. And I don't think I have to explain you that. Monetary means what? Fine, money related. And non-monetary. Yes, so we understand this, right? Let me discuss the main thing for which I have kept it here, okay? Sequence. What? Sequence. What sequencer? What sequencer? What sequencer? Okay. Right. I'll explain you. What am I talking about? Maybe you might be right also. I don't know. So, the whole thing is, suppose we are in section number, let's say 72. Where? 72. And you find that there is penalty given. So that means if you contravene, if you violate section 72, you know that penalty given under section 72 will be applicable. But if it is not given, then what? If it is not given, then what? See, he said miscellaneous. But don't you think he is in a hurry? No, sir, you only said the other day. Wait, we'll come to that also. 72, okay, this is just a hypothetical example. Doesn't give the penalty, then you might see 73, 74. Some nearby sections we'll check. Who knows, in that section they might have given penalty for contravention of 72. Suppose you find, then okay. Suppose you don't find, then suppose there also Batku continues. That means you don't find there. Then what? Then what? General penalty clause for chapter. There are few chapters in company law where general penalty clause is there. That means for the whole of the chapter, they say any contravention happens, then this is the section where penalty is given and that penalty will apply. Like chapter 10, audit and auditors, general penalty clause is there. So if you contravene any of the sections of chapter 10, that section will be applicable. 147 is that section. Followed? ऐसा. Sir, लेकिन अगर वो भी नहीं है, फिर क्या करेंगे? That means then we'll say miscellaneous. Okay, then we'll say miscellaneous. That means general penalty clause for the act. So this is how we understand the sequence in which penalty might be applicable or attracted. First the specific one, boss. That's very clear. Specific section. But if there you don't find, that is where you go to other section or sections. Or general penalty clause of the chapter. There you also, there also you don't find, then move on to general penalty clause for the act. Clear? Now let's compare this. Let's compare this with something very, very simple. Very, very simple. Okay, day-to-day life. Okay, sir. Let's compare it. Suppose your parents are going out of house, home, okay, for something, and you are in classes, so you are expected to come back maybe 2 hours later, and they cannot wait till then. So what will they do? They will lock the house and then keep the keys in the shoe rack. No sir, we already have second set of keys. Then good enough, boss. I am assuming a situation, only one set of keys there. Or 3 are there, but 3 are at home only, not with you. You are a mischievous guy. Right? You may misplace it. You're not that responsible, so they're not giving you those keys. So now what will they do? So we said first possibility is shoe rack, which you know and they know, that's it, no other person knows. So how did you get to know then? Keep quiet, Ray. Chalo. Second possibility, suppose it's not kept there, then second possibility, sir, neighboring auntie, neighboring uncle, there they might keep, है ना, same floor or maybe above floor, below floor, whatever. Third possibility, that means if they don't keep it there, then sir, near our gate security guard will be there, so there they might keep it. That's the third possibility, so that as soon as I enter, that security guard will say, "Arey babu, yes, le lo keys." Fourth possibility, suppose it's not kept there also with the security guard, then fourth possibility is opposite side there is a Lala shop, Kirana store, Lala shop. Okay, don't get so much free. हाँ, पान शॉप बोल रहा, पान शॉप वाले को दिए तो हो गया. हाँ, उधर कौन कौन आके खड़े रहते, and you will go and take it there? No, parents will not do that. Okay, so Lala shop, Kirana store, medical shop. Okay, so there uncle knows us daily, good morning, good afternoon, good evening होता रहता उनसे, so maybe kept there. Okay sir, so four you have talked about. One, shoe rack, specific section, your specific shoe rack, no, specific home. Two, neighboring auntie, nearby, so that means that's what nearby sections we said, other section. Third, security guard we said at the gate, society ka, right, your apartment gate, whatever. Same way general penalty clause for the chapter. And then colony area ka Lala shop, that means what, whole of the act followed. So this way just connected, so that you remember in case you get confused somewhere, then at least this chindi example will make you recall. Okay, so first specific section, if you don't find there, other section or sections. Next, general penalty clause for chapter. Do we have anything like that in company law? Yes, I gave you just now one example, chapter 10, audit and auditors, section 147. Okay, next, don't find there, then general penalty clause of the act. Acha, which is that section? General penalty clause of the act 450. 450, yes, you're right, 450, 450, chapter number 29. So anywhere in the company law, if you don't find specific section, other section, or general penalty clause for the chapter being there, then come to what? General penalty clause for the act. So don't directly come to general penalty clause for the act. Follow this sequence. Okay, it matters. Right sir, we have understood. So now let's discuss that section number 450. Right, 450, general penalty clause for the act. Which act? Obviously Companies Act, we are into Companies Act. So what does it say? What is the penalty? It says company and every officer in default. OID means what? Officer in default, or any other person who contravenes will be penalized with a fine up to rupees 10,000 plus up to rupees 1,000 per day, during which the default continues, subject to rupees 2 lakhs for company and 50,000 for officer in default and the other person. Simple. If you think it is simple, है ना? So company as well as they say officer in default, or any other person who has contravened, who has violated, they might be punished. Because first thing that only comes, who will be punished? So they've answered, company may be punished, officer in default, or other person who contravenes, that person will be punished under this section. Sir, how much will be the quantum of punishment? Quantum, so they said there will be fine. How much fine? Up to rupees 10,000. This is anyways there, fixed, up to rupees 10,000. Plus, depending on the number of days you are continuing with the offense, they will even impose 1,000 per day. But subject to overall how much? 2 lakhs for company, 50,000 for that officer in default or other person. So let us say the offense is there for 15 days. The offense continues for 15 days. How much will be the penalty? You will say, sir, 10,000. Wait, first say 10,000 plus 15 into 1,000, 15,000. So 10,000 plus 15,000, 25,000. That can be the maximum penalty. No, sir, for 180 days the offense continued. So then you will say 10,000 plus 180 into 1,000. So 1,80,000. So 1,80,000 plus 10, 1,90,000. Okay. Sir, 230 days the company continued without offense. 230. Then 10,000 plus 2,30,000. So 2,40,000. However, they said for company maximum how much? 2 lakhs. So 2,30,000, 2,40,000 will not come. Max to max 2 lakhs in case of company. Whereas in officer in default they didn't say 2 lakh, 50,000. Same way some other person is there, 50,000. That's the maximum fine they will impose. This is section number 450. Oh wow, sir. Yesterday we completed section 1. Today we completed 450. And when will we come to 450? That also we understood. Yes, sir. Specific section doesn't give the penalty. Then we go to other section. There also we don't find. Then we go to general penalty clause for chapter, if any. That is also not there. Then we come to this general penalty clause of the act. That is section number 450. Correct? So who will be punished here? Company, every officer in default, and then any other person who may contravene, any other person who contravenes. And what is the quantum of penalty? Up to. Okay, up to means what? Maximum. It can be less also. Max to max 10,000 they are saying. Plus up to rupees 1,000 per day. So maximum 1,000 per day, during which the default continues, subject to maximum of 2 lakhs for companies, 50,000 for OID or other person. Right, sir. Then what is section number 451 or 454A? Exact difference I'll tell you later, but then understand what is this talking about. Suppose the same offense is repeated within 3 years. कुत्ते का दुम टेढ़े का टेढ़ा बोलते ना, कुत्ते का दुम, dog's tail. How much ever you put in any vessel, it will still be the same. So like that, who knows, they are repeating that same offense within 3 years. That too, it's not that 10 years later they are doing that offense. Again, within 3 years itself they are repeating the offense. Then what are they saying? The person involved will have to pay twice the fine. Though imprisonment might be the same, but fine will be how much? Twice. So if 20,000 fine has to be applied, how much they'll apply? 40,000. 80,000, then 1,60,000. Like that, double they will do, because you're repeating the offense, that too within 3 years itself. Okay. वो सेम बॉस जो उधर रहेगा, मैं कैसे बोलूंगा? अलग अलग जगह पे अलग, कहीं बोलेगा 2 months, कहीं बोलेगा 1 month, कहीं बोलेगा 3 months, कहीं बोलेगा 6 months, somewhere they might say 2 years. Depends on the section. Are you getting it? His doubt is, sir, how much will be the imprisonment? So I am saying that depends on the section. That depends what they have specified for that respective offense. It might be 2 months, 3 months, 6 months, 2 years, 3 years, whatever is there, that will not get doubled. What will get doubled? Fine. If the same offense, similar nahi, same we are talking about, same and similar, there's a difference. So they're saying same offense, and that too within 3 years. See, I'm just highlighting those words where you might commit mistakes. Okay, sir. Then, sir, further you have written something in the note. Section 447 is not a general penalty for fraud, or not a general penalty clause. What is it? Penalty for fraud. So at few places you will find that they say penalty for fraud under section 447 is applicable. Penalty under section 447 is going to be imposed. So you should know that, no? That section 447 is not a general penalty clause. It comes only when specifically it is imposed. Please understand what I am saying now. See 450 they will not write 450 penalty will be applicable बोल के, वो हमको समझना है. Got it? Will they write penalty under section 450 will come in this section 472? Will they write like that? 72 will mention that 450 penalty will be imposed. No, we need to understand, 72 is not having penalty. Other section 73, 74 also doesn't have penalty for that. General penalty for chapter also not there. That is where we go to 450. We go to 450. Correct? However, that way we cannot go to 447. No one will go to 447 like that. Specifically, if the authority imposes penalty under section 447, then only it will come. And that is for fraud, which they can impose, not for any offense. समझे? आप फ्रॉड करे, अब वो आपको पेनल्टी लगा रहे, तो कौन सा पेनल्टी लगा रहे वो बताना. आप अपने मर्जी से मत सोचो अरे मैं फ्रॉड करा पेनल्टी लग रहा ना 447 का पेनल्टी रहता. नहीं, आप डिसाइड नहीं करते. कौन डिसाइड करता? Adjudicating authorities. They will decide, they will impose. Clear? So that's where I'm saying it's not a general penalty clause. General penalty होता तो automatically implication से आ जाता था. जैसे 450 आया ना, बोलो आया ना, एग्जाम्पल दिया ना, 72 में नहीं है मान लो, क्या बोला? तो फिर दूसरा सेक्शन देखो, नहीं है उधर भी, फिर चैप्टर का जनरल पेनल्टी देखो, वो भी नहीं है, फिर मतलब 450 में आओ. This way will you come to 447? No. Specifically someone has to say, boss. And who's that someone? Obviously the adjudicating authorities. They will impose penalty under section 447 is applicable. Then it is applicable. Clear? ये तो बाद में डिस्कस करेंगे. ठीक है? Answer to practical questions, how do we do that? Sir, what about 447 penalty? Can we discuss now? No. When required we will. Yes or no? So now some section, let's say 86, there is something relating to fraud. So does it mean now 447 penalty is applicable there? No. Very good. That's not general penalty clause. So specifically when mentioned somewhere, suppose in some section which you are reading, it is mentioned, if this fraud is committed, if this intentionally done, then 447 penalty will be applicable. Then it will be applicable. Correct? Like how I said, adjudicating authority has to impose. Now I am giving you another case. Section specifies 447 penalty has to come. Then only it will come, no? It is specifying. Let's say it's specifying. You will come across those type of sections where they say contravention of this or this sort of default will lead to 447 penalty. Then 447 penalty comes. Clear? Important thing, these type of things we can't miss it out. So let's revise quickly all this. Chapter number 1 to 29, right? 1, preliminary. Which sections are there in preliminary? 1 and 2. Good. Next. Second, incorporation and matters incidental thereto. Prospectus and allotment of securities. 4, share capital and debentures. Very good. Deposits. Charges. Only one person is answering. What about others? Management and administration, including general meetings. right? You're able to recall, no? Director's appointment and qualification. 12. Board meetings, powers, restrictions. Appointment of managerial person, powers. Powers, no sir. Remuneration. 14. I. Inspection, inquiry, investigation. Compromise arrangement. 16. Prevention of oppression and mismanagement. Registered valuers. 18. Defunct companies. 19. Sick companies repealed. Repealed, no, sick company is not there now. Correct? They have repealed the provisions. But still we will remember. We should know. Someone ask what is chapter 19? We'll say sick companies, but it is not there now. It has been repealed. It has been omitted, deleted. 20. Winding up. Correct. 21. Unregistered companies. 21A. Producer companies. 22. Foreign companies. Right? In short, we said foreign companies, you may say. Then 23. Government companies. 24. So 26 we know immediately. What is 26? Nidhi companies. 24. Registration office and fee. There only we'll talk about registrar. 25. 25. Company to furnish information or statistics. Only fees? No. Fees, then information. You remember like that. Then 27. NCLT, NCLAT. Special codes. Miscellaneous. Very good. So like that 1 to 29. Out of that, how many are there in our syllabus? 1 to 10 plus 22 plus 29 indirectly. Section wise also you observe. Okay. 1 to 3 to 22. Like that you just observe. 1 to 10 means 1 to 148 sections. Which is the section there? 148. Just check it out. In chapter 10, we have got the last section as 148. So that means section 1 to 148 is in our syllabus. Plus 379 to 393. 379 to 393 companies incorporated outside India. This much is there in our syllabus. But as I've told you, we will have to take the help of few sections from miscellaneous. Okay, few sections from miscellaneous like 447, 450, and same way I will let you know which other sections are relevant for us. That also we will go through. But as such, syllabus wise 1 to 148 and 379 to 393. That's what ICI has specified. Plus important rules. Don't forget that. Plus important rules. They've written no. ठीक है. Schedules. 1, 6 and 7. 1. Whenever I ask you like this, you'll say schedule 1. Suppose I am asking, then you'll say table A to table E is MOA, table F to table J is AOA. 6. Infrastructure activities. 7. CSR, corporate social responsibility. Correct? Yes sir. Okay. How many RDs? How many regional directors? 7. Very good. 7. How many states have got 2 ROCs? 2. Maharashtra, Tamil Nadu. Telangana, we have only 1 ROC. Okay, Maharashtra 2. Pune and Mumbai. Tamil Nadu and Chennai. Good. Chennai and Coimbatore. Good. Model articles are given in which table? Right, because if I don't specify anything, that means company limited by shares. So I believe you have followed it. You understand. So now let me show you the, as I've told you, the Bare Act, the official gazette. So this is the official gazette. So this sir, this one. So it's written there, Bharat Ka Rajpatra, the Gazette of India. Okay, so sir, like how Deccan Chronicle, Times of India newspapers are there and at the top they write. If you remove that, then it's a normal paper. Same way, like this. Same way, official gazette is like this. Yeah. Heading on the paper, heading should be what? Gazette of India. Heading is there in two languages, one Hindi, another one English, right? So now see, what could you see there? What could you see there? Companies Act 2013. You're able to see. That means this is the bare act of the Companies Act 2013, which got published in the official gazette. Which got published in the official gazette. Okay. On which date it got published? 29th of August 2013. It got published on which date? 29th of August 2013. And this was the date when President gave the assent. And 30th August 2013, what happened? Section 1 was implemented. Very good, you remember. And then, yeah, later on September 12th, other sections, few sections were implemented, and then it went on. Good, sir. We can understand. So what did they write there? You just see. What did they write there? An act. Sir, but before that, see, ये तो है यहाँ Companies Act है. यहाँ क्या लिखा हुआ है? Number 18 of 2013. What do you mean by this? In the year 2013, this was not the only law which the Parliament passed or which was introduced, which was implemented. But there were 17 more. This was the 18th one. Understand? And don't think this is the last one. Who knows? 1920 might be there. They are there for your information. But we don't have to bother about that. We have to bother about company law. So thereby I am showing you company law, and that is number 18 of 2013. Okay, sir. Now further you read. What is written there? An act to consolidate and amend the law relating to companies. What is this? Preamble. So did they write preamble dash? No. No side headings. They didn't write any side heading there. Simply have written, we understand that's preamble, that's objective in short. Clear? Be it enacted by Parliament in the 64th year of the Republic of India as follows. This is the wordings you will find, this is the style that you will find. They follow. And then what do you have? Chapter 1, correct? You could see chapter 1 there. What is the heading of that chapter? Preliminary. That's what we said. How many sections are there in that? 1 and 2. So 1 you could see on the left hand side. Section 1. And then you will find section number 2. Dikh raha hai? Section number 2. Okay. So now, sir, section number 1, what is the heading? Section number 1, what is the title? You want to know that? Yes or no? And where are you able to find that? Dekha? Short title, extent, commencement and application. Where did they write? Right hand side. They have not written horizontally. They have not written at the top horizontally. Okay. They have written in the margins. Right side. Correct or not? That is why please understand it is called as marginal notes. So if someone asks you what is marginal notes, what will you say? Title of the section. What is marginal notes? Title of the section. Sir, is it always on the right side margin? No, it can be right, left, right, left. Just observe now. देखो आप लोग यहाँ. Definitions. Where is it there? The title of this section 2. Definitions. Where is it given? देखो, left side. So right side you had section 1. Left side section 2. Title of section 2. Getting it? So like that, if you just scroll down, you will find section 3. And where will you find the marginal notes for it? Title of section 3, right side. Section 4, left side. Like that it will move on. Go on. समझ में आ रहा है? Okay, sir. Sir, section 1 we have completed. Now let's read how the language looks like. So see, section number 1. Padho na? The act or this act may be called the Companies Act 2013. It extends to whole of India. This section shall come into force at once, and the remaining provisions of this act shall come into force on such date. And so see, this section, meaning section 1, will be implemented at one go. That's what they said. Will come into force, shall come into force at once, and the remaining sections shall come into force on such date as the central government may by notification in the official gazette appoint, and different dates may be appointed for different provisions. So it's not that different other provisions single date. No, they're saying different provisions, different dates. And any reference in any provision of the commencement of this act shall be construed as a reference to the coming into force of that provision. So if they said section 56 on this date, then that date. Section 36 on some other date, then that some other date. Correct or not? Next, the provision of this act shall apply to, come on, read boss, companies incorporated under this act or any other previous company law. Next, correct. Same way banking, same way electricity, same way they say other companies governed by special act. Then also they say such body corporate incorporated by any act, and central government may notify it. So you got it. Title, extent, commencement, application, all the 4 are there in section number 1. Section number 2 has got what? Definitions. Now you just see here, section 2, they say in this act, unless the context otherwise requires. Abridged prospectus means, accounting standard means, alter or alteration includes, appellate travel, like that they've given no one by one. Yes or no? 1, 2, 3, 4, 5, 6. I've told you how many are there like this? 95. 1 to 95. 7, 8, 9. So now question comes, sir, what are these called as? This 1, 2, 3, 4 in this section 1, what is it called as? Section 2, what is it called as? Clause. And then comes the question, sir, in this section 1 also we could see 1, 2, 3, 4 like that, no? 4 are there, no? 1, 2, 3 and 4. See, 4. These are subsections. If you just see section number 1, just observe here, look at the board, okay? Section number 1, beside that is number 1 in brackets. Correct? And now you observe section number 2. Immediately 1 started. Do you think immediately 1 started here in brackets? No. First what is written? Some line is there, sir. In this act, as I've read, no? Already I've read. In this act, unless the context otherwise requires. So this line is there first, and then this numbering are there, or numbers are there. So that's where it becomes what? Clause. And that becomes subsection. There we didn't add any line. Directly section 1 and then 1, 2, 3, 4 started. So that is subsection. That is how we identify. And this is, come on guys, answer, clauses. So clause 1, clause 2, clause 3, clause 4, like that. Okay, sir. So now if you just see, it goes on, the list goes on. Okay, let's see, 1 to 95 are there or not. है ना? Acha, which date this was issued? Is it of today? This bare act is of today? No. When it was published in the official gazette, it is of that date? No. So do you think now today when we are reading, only reading this will be enough? No. We'll have to add amendments, amendment acts. Then only we can say we are reading updated bare act. Correct or not? So now question comes, sir, why to waste our time on this? Rather we will buy a bare act of the private publisher. Didn't understand. See, this is the bare act published by the government in official gazette. Rather than referring to this bare act, because this bare act is the bare act published on in 2013. Let's forget the date as of now. 2013. But we are in 2023. So since 10 years there have been amendments, amendment acts. So if we read only this standalone, we are reading outdated law. So that's why we should even combine amendments, amendment laws, so that we are reading updated bare act. So I am saying, don't you think this is tedious exercise, difficult exercise, combining this with that and then reading? इतना easy रहता क्या? नहीं. तो मैं बोल रहा हूं इसकी जगह पे बेटर है that we buy the bare act of private publishing houses like Taxman, Bharat, ऐसे है ना publications. If you don't know, probably then I'm sharing with you. Okay, there are bare acts like this. Do you think we should buy? Yes. So advantage will be, sir, advantage क्या? There will be a cost involved. हाँ, cost है, but then there is a benefit also. What is the benefit? All, yeah, easy reference. All those sections which have been amended also will be properly written there. Here what will happen? You will have to take the help of amendment acts. It becomes difficult. Like I was telling you, 2 clause 94A is there. I've told you or not? Yes, but now you find, will you find here? No. Why? 94A means what? Amendment. So you will not find it here. Okay. मैं जानबूझ के थोड़ा स्लो स्क्रॉल कर रहा हूं, देखते रहो आप लोग. प्लीज ट्राई टू ऑब्जर्व. Read 72, 73, 74, 75, 76. You're not finding any 76A, 77A and all, right? Maybe this got upset. 77, 78. Sir, it has become smaller now. We cannot see. Manage, no problem. Right? I hope you could see 94 and you could see 95 there. No 94A in between. Why? Because that was brought in later by way of amendment. And this is the bare act. Obviously, bare act when it was originally issued, 2013. So it becomes difficult to refer amendment acts along with this. That's why what people do is, instead of referring to this bare act, they refer to the bare act given by the private publishers. They pay for it and buy. And secondly, in that private publishers bare act, you will find also some commentary. Some commentary. This was removed, that was brought in, this, like that. They'll write something more. So it helps that way also. So if someone asks you, Arey, why we should buy that? Rather free of cost we are having this, right? So what will you reply? Now you got the answer. You'll say, no doubt that is going to incur some cost, but it's going to save our efforts, time, and also easy references possible. Okay, so with this, let's wind up today with a promise to meet tomorrow, right, in our next session. So thank you so much. God bless you all. See you all in the next session. Acha, and you know your homework on a daily basis. What's your homework? Revising daily basis. Whatever we cover, make sure that you revise and come. Okay. Thank you. Bye bye.